Okay, it's about 5 minutes after 1 o'clock. We're going to go ahead and get started now. By way of introduction, for those who I have not had the opportunity to meet, who have joined us this afternoon for Show Me the Money Association Collections, my name is David Cohen. I serve as Executive Vice President of ACAM. ACAM is a full service management company providing exceptional management services to properties throughout South Florida, as well as New York and Manhattan. We manage here in South Florida about 20,000 units over the course of about 700 employees. I'm joined today by Ken DeMoss as well as John Cunnell from Adorno, Cunnell, and DeMoss Law Firm. I'm going to turn it over to Ken for a brief introduction.
Good afternoon. Nice to meet everyone. My name is Kenneth DeMoss. I'm the partner along with John Cunnell at the office of Adorno, Cunnell, and DeMoss. We specialize in collection efforts for association. We are association attorneys, and what we bring to the table is we bring together that litigation background. We are in court, well, now it's via Zoom, but we're in court day in and day out, litigating matters, and are very familiar with the protocols that are needed to obtain collection practices in the building. We'll talk throughout this presentation on different things we can offer and different strategies to collect on behalf of the association that we believe will be prudent in these COVID times.
Excellent. Thank you, Ken. And for all attendees who are joined us this afternoon, feel free to use the Q&A section on the bottom of your screen. We'll be taking live questions throughout the webinar this afternoon. Today's webinar is focused, as I said earlier, on collections. This will be more of an open dialogue, open conversation with some Q&A. But again, we want to hear from you. So if there's a specific question that pertains either to your community as a board member or as a licensed community association manager, we certainly want to be a resource to you. And of course, after the webinar, this recording will be made available to all attendees. And if there's any additional resources of support that we can provide to you, ACAM, as well as the law offices of Adorno, Cunnell, and DeMoss will absolutely be available to you. To kick things off, Ken, I'd love to get started with some current trends of collections, specifically during the COVID crisis. You know, this is a question that does come up quite a bit. Can you share with us some of your experience with regards to the collection environment during the COVID environment?
Yeah, there's we've represented, John and I, we have several buildings where, we receive them with a high default rate, delinquent rate, and then within 6 months doing a protocol that we'll describe, we've lowered them significantly. We are seeing now another trend of a lot of, given the times, a lot of residents falling behind on their association. Not only that, but we also have the tenants not paying. It's kind of like a trickle down effect where some unit owners have their units rented and their tenants are not paying them, and then in turn they're not paying their association dues. And people and boards are misguided, thinking, well, there's false hope, there's no real collection efforts allowed, there's no foreclosures going along in Dade County, and that's kind of false because as everyone knows, the stay is lifted as of January 4th. So when we're looking at the stay of foreclosure in Dade County, it has been the highest since the burst of 2007. I was looking at the foreclosure before this meeting to see how many pages the foreclosure list is. And right now we're looking at a total of approximately 96 pages. On a normal foreclosure calendar list, you're looking at about 12 pages. So that just shows you how much backlog and how much inventory could be on the market. So what we offer, and I'll let John chime in, we do a kind of a pre-foreclosure effort and then a post-foreclosure effort, kind of to speed the process along. And we do it in 3 steps. We do it the pre-collection stages where we send out a 30-day demand letter, just kind of tell them what's due. It's a $75 letter to the association, which we recoup the fees from the unit owner. If they do not pay, we lien their unit in 60 days. Okay. At that juncture, if they don't pay, we immediately file for foreclosure, and then it completes that process of the foreclosure, so that for transparency purposes, we break out our fees in 3 stages. Stage 1, the first fee will be due upon filing, stage 2 upon judgment, and stage 3 upon the sale of the unit or resolution. And we find that need keeps the process going. John, I don't know if you have anything to chime in.
I would just also mention that during this time and the unprecedented pandemic that the community was faced with, we also were always staying abreast on our governor's orders, the CDC's updates and mandates, the mayors. Sometimes you have your municipal mayor, your county mayor on their ordinances or executive orders that they were putting in place. Assessing those mandates, seeing how they fit, how they apply to the association, how can the association regulate the common areas, are there rules that can be implemented, finding committees. We'll write legal opinion letters relating to that, also letters regarding whether or not board meetings can be conducted virtually, can they be done with a hybrid type meeting and still meet the requirements of the statute and comply with the condominiums documents and bylaws. So it's more than just doing our foreclosures, and ultimately, yes, the money and the revenue is what's important for the association, but at the same time, assisting the board and the association when needed regarding compliance issues. We try to stay on top of that.
No, that's very helpful. In fact, you know, from a management perspective, we have a very particular and precise collections procedure that we implement for all of our clients. We also have a collections department at a corporate level. So prior to an account going over to the attorney's office, we do everything we can to, number one, communicate with that owner, which in our opinion is the most important, is the communications aspect. And then obviously if the association and our office is not successful, to then turn that account over to the association's attorney, such as your office, for further collections activity. And then as Ken said, the lien after 60 days. You know, with regards to that process, what happens in your case when an association can't locate an owner? You know, it happens here in South Florida all the time. It's second, third, fourth homes, investment properties, and sometimes the owner is not accessible. Well, what do you do in that scenario?
Well, it depends. It depends whether the property is held in the name of a company or in the name of an individual. If it's in the name of the company, I'll let John chime in on the company. He's the company expert on it. If it's on an individual, we can't locate them after we do a skip trace search on the individual. We do proceed with service by publication and proceed to foreclose based on publication. John could chime in terms of if it's held in a corporation, which a lot of properties are in the state of Florida. And I'll let John chime in on that.
Ultimately, as you said, many of these units are owned by corporate owners because they are foreign owners or foreign investors that had purchased the property. That being the case, you can always serve the registered agent of the corporation, which would have to be in the state of Florida, and that would be easily identified on the Department of Corporations webpage. So we'll do a little research there. We might run a TLO search, locating some of the previous addresses if it's an individual owner, but then as far as the corporation, as the statute requires, we would serve the registered agent as reflected on Sundays.
And John, just so I hear that correctly, because I know it's a question that comes up quite a bit. If it's a corporation that owns the unit, you're saying that the registered agent on the Department of Corporations must be located in the state of Florida?
Yes, that's correct.
Okay.
And there's this, you know, the statute regarding service of process clearly spells it out, and Ken's written, I think, a couple opinion letters on that and litigated a few cases. I think one of our cases was appealed regarding service, so we're familiar with that. I mean, ultimately, you are dealing with, although it's a collection effort and a collection attempt, you're kind of collecting on against your own neighbors too at the same time. So going back to what you initially said, yeah, it is good. It's great how you would incorporate trying to do all you can on your end to collect, to locate, and get that payment in before it's sent to the attorney's office, where we may be ultimately aggressive by filing the action.
Understood. Now, something we see a lot from a management perspective is units that may be delinquent that have a tenant occupying the unit. In a situation like that, can you walk us through the steps of how you would collect from a tenant until that unit owner is brought current on their maintenance assessments?
Yeah, so under the statute, you're permitted to write a demand letter just as you would if it was your tenant, and have the tenant pay the association directly until the unit owner's assessments are paid in full. Now, interestingly, and just to piggyback, in these times, and I've encountered that in some buildings here in Brickell, we've encountered unit owners that reach out to management and to the board and says, hey, listen, I'm having a rough time paying just my basic necessities. I need help. So we do a hybrid, and it's kind of interesting. We actually do settlement agreements between not only the unit owner, but also the tenant and the board. So that way, we're not collecting the entire amount of the rent from the actual tenant, but we're applying a good portion of it towards the assessments so that everybody could kind of flow through it. And then we put in a safeguard in these settlement agreements that in the event that they default on it, how it would speed up the process of collection. And it's not dischargeable in bankruptcies, and we could get into that if you want to in a later time, but we kind of build in a lot of safety mechanisms in our settlement agreements that would alleviate the need to pay the expense and time of having to proceed collections, and at the same time protects the actual association accounts.
That's helpful information. And again, I want to stress, and you'll hear me say this quite a bit, you should certainly speak with your professionals, speak with your management company, speak with your property managers, speak with your legal counsel. If you need support, the three of us are available to you as board members, as licensed community association managers. John and Ken, it brings me to another question. We talked a little bit about how you collect from a tenant. What about payment plans that get put in place? Let's just say the unit is not occupied by a tenant. In this environment, as Ken, you alluded to, where owners are having a difficult time paying their maintenance assessments, we're seeing more and more owners look for a payment plan. Can you tell us how you structure that, how you enforce it, and if a unit owner doesn't comply with that particular payment plan, what the next steps in the collections process may be?
If the, there could be a couple different avenues regarding payment plans, but if you're talking about a unit that owes past due monthly maintenance fees or special assessments, what you would do is we would draft up a settlement agreement, and that settlement agreement would incorporate a number to slowly catch up on the past due amounts, while at the same time bringing the unit current with the ongoing monthly payments that would continue to accrue. Now, in the event that the agreement was breached by the homeowner, and sometimes the homeowners do breach the agreement, we take that breach, that default of the agreement to the board, and we ask the board, how do they want to handle it? Do you want to immediately move forward seeking to enforce the agreement? And that agreement will have what we call a hammer clause, which will allow the association to expedite foreclosing on the property or taking title to the property. That'll be incorporated into the agreement. Most of the time, the boards are understanding, and they'll take a look and they'll say, okay, this payment plan was supposed to bring the homeowner current within nine months. They missed one, they missed two, but they're able to make maybe a smaller payment. And then at that time, we'll modify or revise the agreement. I think the biggest issue that the associations become alarmed is when there's just a complete disregard by the homeowner. As long as the homeowner is compliant and the association is able to be collecting revenue on their receivables, then it's generally better for them to keep that homeowner in a payment plan rather than just breaching it, letting it go, and having no receivable income coming in. Ultimately, the short answer is we just set up an agreement with a hammer clause. You don't pay, we can move after the unit quickly and allow the association to rent it out.
That's great information. On that same token, a question that I've seen come up quite a bit is a unit is occupied by a tenant. The unit owner is delinquent in their assessments to the association. and the tenant is no longer paying their portion of the rent to the owner. Can the association take any action against the tenant for eviction?
Yes, they absolutely can, but it takes a little bit of analysis, and that's where we come in. And when we lien the unit, let's say at the 60-day mark, at that juncture we run title on the unit to see if there's any foreclosures or anything on that unit, and we kind of time it because it would make no sense for the association to expend money on an attorney to proceed on a foreclosure effort, and the bank's about to get judgment of that unit, right? So before we proceed to either an eviction, which, just to answer a short answer to your question, is yes, you can. We analyze whether it's prudent to do so, or if it's prudent to proceed with a collection effort in regards to a foreclosure, after review that title search. That's one thing I want to stress is very important, because there's many times that, if you don't do that and you go ahead and file, lo and behold, you're filing against nothing because the bank just took title and then they're protected under the safe harbor. So that's something that we're very cognizant on when we do these cases. And I fear we're going to see this a lot because we experienced it, and John and I experienced it quite often back in 2009, 2010. And I hate to say it, but I feel that we're going to run into that same issue in 2021.
Can you elaborate a little bit on, what you foresee as far as foreclosures in the new year? You mentioned at the beginning of the dialogue, the docket's looking like 96 pages versus, a normal 12-page environment.
I think it's a trickle down effect. I think because there was such a long stay given with the foreclosures since COVID began all the way up, and they continue to stay until January 4th. I believe that all those foreclosures that were set to go, that's why you're seeing such a heavy number in January. I do see, though, more and more foreclosures being filed, and it's a trickle down effect. If you have a stay on evictions and the tenants are not paying the homeowners, and homeowners are not paying their banks or their taxes or their property assessments, I just see it, ballooning. It's not like that in every building, but in some of the buildings that we deal with, I would say that, I think it's a safe number to say 30 to 40% of them, we're seeing an increase of collection matters being sent over to us.
For attendees that have joined us today, can you just elaborate a little bit on the stay for foreclosures? You mentioned that goes up January 4th. Is that the same timeline for the stay on evictions?
Yeah, well, there's evictions that were filed pre-COVID. The mayor has allowed those to proceed with a writ. However, evictions that are filed post-COVID, there is a stay not by the governor, but by the CDC that extends until January 4th, 2021.
Understood.
Now the big thing, just to clarify on stay, is it doesn't prevent you from filing. So it's important to know that, because it doesn't mean you have to wait on the sidelines and wait all the way up to January 4th before you file a foreclosure action. You could file a foreclosure action and go all the way through to judgment. You won't be able to execute a sale date until January 4th.
So let's talk about that a little bit. You mentioned a very important piece, that associations don't have to wait to be aggressive on collection efforts, number one, and number two, placing a lien on an individual's own unit and then proceeding with foreclosure. Can you talk a little bit about the steps? The notice, you mentioned that the notice to lien the unit is around 60 days from the time it comes to your office. Can you talk about the priority of the lien, who holds priority, what items can be placed on a lien?
As far as the association lien, like Ken said, 60 days after we send a notice that there's going to be an intent of the building, the association, to place a lien on the property, and then 90 days into it, generally a lien is recorded on the property. That lien ensures the association's right to collect their fees from the date that lien was recorded. There's a priority of liens. You might have a mortgage that's in front of that lien. You might have a mortgage that comes after that lien, but the lien belonging to the association would give them their priority is based on the date of recording. So it's always best to get that lien recorded as quickly as possible. And that lien would guarantee or ensure payment of interest, assessment, attorney's fees, costs related with the that unit and its outstanding balances due.
Can you talk a little bit about your services as an organization? You know, what do you charge for services for collections? And then talk maybe a little bit about how the association recoups those costs, if any.
So how we do it is we bill at a discounted hourly rate of $300 an hour for work done. However, for what we consider pre-foreclosure steps, for example, the 30-day letter, we charge a standard $75 fee for that. And upon the 60-day claim of lien, we charge $75 for the 60-day notice and the $10.50 recording fee. Okay. After that, when it comes to the foreclosure, to be competitive, what we do is we charge a standard $1,500 flat fee, which is divided in 3 equal payments. First payment, $500, is due upon the filing. The second payment is due upon the receiving of a judgment. And the third payment is upon sale or conclusion of the case. The reason we do that, David, and I think it's very important, one, it keeps everybody pushing for the same result to conclude and not to have a stagnant file. It makes us want to work harder for you and makes you want to work harder for us to be able to get, you know, stats that are important for the association. Another thing that's important, I just want to kind of boomerang in back on the lien just to tell some of the attendees. A big thing with the liens and the reasoning that it's important to move forward on them is we have here in Florida, as you all know, we have a safe harbor standard, right? So if you sit on the sidelines and do nothing, and you know there's 3 or 4 years of assessments that haven't been collected, the bank, if they foreclose, they're only responsible for either 12 months or 1% of the outstanding mortgage, whichever is lesser, right? So a way to safeguard that is, you know, in the event that there's no resolution with the unit owner, is to move forward, foreclose, get lien, get that property. Either the association would own it, be able to collect rent from it, or in the alternative, a third-party bidder would buy the entire lien amount and make the association whole. And that's something that John is very well versed in. He's been very successful in negotiating with third-party bidders and obtaining judgments for the association. So it's something to keep in mind in the back of your head and the importance to move forward.
Ken and John, what type of advice would you give a property manager, for example, or a general manager of an association with regards to keeping their collections down? You know, obviously, the most important aspect in dealing with collections is, one, the association becoming whole, and 2, avoiding as many costs as possible, especially as a not-for-profit organization. What type of advice would you share with a property manager with regards to their collections?
I think the first and most important thing is communication. Communication between the property manager and the residents. Communication between the property manager and the board members. Communication between the property manager and the law office. Communication is important. Kind of keeping a track of, you know, what's going on, what's the feel, what's the pulse of the actual building, and then relaying that information to the board members and to the attorneys. Me personally, and I know Ken is on board with this as well, I like to see all the units that are 31 days late in that building hands-on. Ken and I, sometimes it may just be a coffee meeting in the morning, but I like to know when units are 31 days late.
That's great information. You know, I'll tell you from our standpoint, you know, I think you guys know we manage about 20,000 units in Florida and another 45,000 units in New York. So we're not small by any means, but I agree communication is critical, from the corporate structure, if you're with a property management company, to the property manager, to the collections department, and of course, legal counsel, who really takes that and the collections process to the finish line.
I think another thing, just to throw this in there, is a good amount of communication also with the accounting department, on the management team side. The accounting department, they're numbers people, and that's what this boils down to, is numbers. And they can really You know, sometimes the property management, the on-site property manager will be able to get you some information, but having a good, you know, email rapport, or, you know, picking up and texting or making that phone call to the actual accounting department at the property management company is also invaluable as well.
I agree. I think a lot of property managers and even board members, whether it be the treasurer or another appointed board member, you know, omit is reviewing their receivables report on a monthly basis. I mean, that is so critical. I'll tell you, part of our procedure at a corporate level is between the 15th and 21st of every month, we send a reminder notice to every single homeowner that is under our management with a reminder that they have a past due balance and need to bring their account current. We do that at no charge. Associations that we service, it's included as part of our management services. And we're seeing that it has a positive impact on keeping the number of receivables down. Unfortunately, in this environment with COVID crisis surrounding us, it's changed our lives. And a lot more owners are having difficulty. And I think a big takeaway from this conversation has been the payment plans that you guys alluded to. Are you seeing a lot of those in place compared to previously before COVID?
We have, you know, a fair amount, a very large amount. And another thing, and kind of jumping on the bandwagon is your services, ACAM has a great mainframe when it comes to their computer system and their login portal. I know, me being a little bit of a tech geek, I think it's very fascinating. Our office invested in a very similar software. So what we have is we have communication where the residents can actually log on, or the property manager could log on and actually know, okay, well, it's, you know, November 19th. Well, we know that Joe Schmo from Unit 202 has a payment due in terms of payment time tomorrow. And did he make it? And they'll be able to actually, the property manager will be able to log in and actually follow those payment plans within our system. They would also be able to log in and follow the collection efforts. When was a 30-day sent? When was a 60? Pull it up on their screen, as well as a foreclosure case. So it's kind of, you know, just jumping on, you know, the communication, the accounting. We also provide that to help and assist the property manager.
Staying on the topic of communication, you know, we obviously have maintained a very great working relationship with your firm. We've been successful at keeping our mutual clients' receivables down. What type of meetings can a new client expect from you? Let's say a new client engages your firm for collections and even general counsel efforts. What type of meetings will you hold with them? What type of ongoing dialogue will you have with them to make sure that everybody's on the same page with regards to their legal matters, and in particularly collections?
Well, we built, and I think, you know, you could speak for us, and I think our building will speak for us. We built our whole practice in communication. You know, we're in the service business just as you are, and we believe that providing, you know, access to an attorney is vital. So in our business card, on my email signature, on John's email signature, not only do you have the office's phone number, but you have a personal cell phone that we carry, we're addicted to. We carry 24 hours a day. Also, our mainframe system provides access where they can log on, they can access us, they have a question at 2 in the morning, they don't want to call us, they can actually log on to our system and see that. In terms of meeting, we always make ourselves available. We take pride that we're a boutique law firm at a Brickell. We've been established for quite some time. And, as I said, coming in, my first client out of law school continues to be my client, and I believe is now an ACAM client. So, we take a lot of pride in keeping our clients happy, and I know John supports and carries the same belief I have.
I could certainly vouch for that. When you talk about service levels, you mentioned that you're a boutique firm. You obviously have a very large portfolio. However, having that personalized service with your clients is extremely important. It's something that we preach day in and day out. How many lawyers do you have in the firm?
Currently, we have 5 attorneys.
Fantastic.
I would also say that some associations are a little different in the way they approach things, but we're also available to attend special board meetings, general board meetings, any kind of special event that the association is hosting, you know, especially pre-COVID, and I'm sure as all things do eventually pass, this will pass as well. We'll resume being in person at these meetings as needed and as requested.
You know, we've talked, sorry, go ahead, Ken.
And another thing, David, that while John reminded me was talking, we're also not limited to just collection efforts. As I said, when we started in, we do a lot of litigation. John deals a lot with property use issues. We also do a lot of construction defects. We represented buildings on some certain construction defect cases with drywall and during the hurricane. So we're well versed in the event that the association needs us to step in or consult something, we can actually do that as well. We're not just, you know, paper pushing, you know, collection attorneys. We are litigators.
You know, Ken, you stole the words out of my mouth. I was actually going to segue a little bit into annual meetings, just because we are in that environment as we speak, and your firm, although you have a fantastic platform for collection efforts, you know, you do provide general counsel to a lot of associations. You know, attendance by attorneys is always the question when it comes to annual meetings. Do we have the attorney come? Do we spend the money to have the attorney come? What is your opinion as legal counsel for associations? And I'll give you my opinion.
I think it's important, not so much because, I mean, not for self-interest. I think it's just important for transparency reasons. Time again, we've been, and John has been stuck in as well as I have, with meetings where after the election, you get some sort of, oh, it's a rigged election, there's not transparency or whatnot. And I think having counsel present during these meetings are very important. One is because we oversee it, and we could vouch as an officer of the court in the transparency and the protocols that are followed in it. Two, I think if there's any question posed on timing and when the election is closed and who can vote by proxies, I think those are better answered by an attorney who is present. But some associations, there's some associations that really needs that. And there's some associations that we deal with that are very self-sufficient, and they're smaller and, you know, kind of like kids. They all get along and they may not need us. We always offer our services. If they want us there, we'll make sure we're there. If they said, we have this, we don't need it, we're available by phone. We kind of leave it up to the client not to, you know, impose ourselves, but I do think it's important.
I think I agree with Ken. I think it's important, and you go to these meetings, and it's an important meeting, definitely that annual meeting, and you know the attorney should be there. Sometimes the management company has corporate representatives there. It's a meeting that takes a little higher level of seriousness. Also, you know, there's sometimes different vendors are there, so I think it's not only are you representing our law firm while we're there, but we're representing to the members and the homeowners that, hey, the association, the management team takes this meeting very serious. You know, we're going to discuss your numbers. We're going to discuss, you know, partially funding reserves or fully funding reserves. We're going to discuss important matters, and it's of that importance. We're asking, hey, counsel, can you be here? And different other important players in the association collection process. So I think it's important. I think it looks good. You know, I lived in a condominium for 16 years myself, and I always thought it was very professional when executive level people come and you're a member of that association. You see that. I think it sets a professional tone.
I think that's very, very good advice. You know, we have the privilege of managing about 300 properties, and we have experts on staff in every facet of association management. I would still recommend that the association's council participate in annual meetings. I agree with you. I think it sets the right tone. It sets the right transparent message to the membership. You know, while the property managers should certainly be more than qualified to run the meeting, having third-party representation such as legal counsel participate in those meetings, I think is the right message being sent to the association and the membership. And I assume that you work with your associations with regard to preparing those annual meeting notices, budget meeting notices. You know, obviously we're in that forum as we speak. So, you know, I think this is good advice to property managers and board members in attendance.
Yeah, and there's some associations that are counting their ballots electronically as opposed to in person. We set up those protocols in the system with that. as well as organizing a hybrid of the two, which we're currently facing with one association. So yeah, we guide them towards the whole process from start to finish.
Well, if there's nothing else to add, Ken and John, I think that this was a very productive open dialogue. If there's no, I see there's a few Q&A, so let's take a few minutes to see if there's, so Joseph Torok has a question. Is a retainer for the association lawyer count towards any services?
So if I understand the question, we don't charge anything up front. So it would be just the standard retainer, which we'll start billing as we work. So the $75 letter for a 30-day notice, that would be charged once the letter goes out. So we bill as the work is done. The only fee that we collect ahead of time is the filing fees for the foreclosure, because we pay that out of pocket. But other than that, we pay as we go. I'm not sure, Mr. Tarak, if I answered your question. I hope I did.
Looks like that may have answered his question. Yes, he has confirmed. If there's anybody else that has any questions pertaining to the subject matter, we would be happy to take them at this time. Otherwise, a copy of the webinar will be made available electronically for those that want to watch it again or share with their fellow board members or personnel. And again, I want to take this opportunity on behalf of ACAM to thank everybody who has joined us this afternoon, and specifically Ken and John of Adorno, Cunnell, and Damas law firm. Always a pleasure working with you guys, and I thought the information was excellent.
Thank you so much.